Your estate plan is only as good as the documents it's written on. And if those documents are lost or destroyed, your plan could be in serious jeopardy. So I wanted to take a minute or two to talk to you about important details in safekeeping your original documents. After you've signed your documents and you're taking them home, it is very important to consider how to make sure that those documents won't be destroyed and will be findable by your executors, beneficiaries, or those who will be carrying out your plan. In Kansas, generally speaking, only original estate planning documents are considered valid. If originals are lost, damaged, or destroyed, there is a presumption that you intended to destroy them or shred them, or that their terms would not be binding. There are some proceedings that would permit copies to be used. Those proceedings can be costly and do require the consent and approval of all interested parties before using a copy. Because of that, it is very vital that you ensure that your documents are kept safe and are findable. So usually it narrows down to keeping your originals in one of two spaces. I usually recommend either keeping your documents in a fireproof safe at home or a very known and findable location, or a safe deposit box at a bank. If you keep your documents at home, it's very important to make sure that those documents are findable. It happens plenty of times that I have to give the bad news to family members who call in and say they can't find their loved ones' original estate planning documents. I have to tell them that unfortunately, copies cannot be used in every instance, and we might be left in a situation where the legal presumption is that there are no documents in place. So if you're going to keep your documents at home, it's important to make sure that your loved ones or important parties know where the documents are located and would have access to possibly the combination for the safe, or they would need to know who to contact in order to get a hold of the contents of your safe. If you're going to keep your documents at a bank, it would be a very good idea to have a power of attorney in place that states that your agents, if you are incapacitated, would have access to your safe box, and you should give the bank a copy of your power of attorney stating who can access your box ahead of time. If there is an emergency that arises, the bank is already made aware of the agents you have designated who can go in and access your original estate planning documents. If you keep your documents at home, please remember that only you can create your documents, but anyone and anything can destroy your documents. So it is important to know that whoever can have access to your documents, whoever you do disclose the location of your documents, you make sure that they're not people who are going to be bad actors, who wouldn't be incentivized that those documents might disappear one day. It is important that the estate plan that you invested in and paid for would be carried out to its terms. Part of that is that the originals are preserved and very findable by all the parties who will be affected by it. You've invested in having a detailed plan put together that makes your intentions legally enforceable. You need to make sure that the estate plan that you just invested in will survive the years, but also will be findable by the parties affected by it, so that they can carry out your intentions after you become incapacitated or deceased.